Okay, everybody, we're here for another session on property and a video lecture. My able assistant started this out for me. If you need me, robdawalt@me.com, property, and we're going to talk about deeds this time. Okay, so some interesting facts on deeds that I want to share right now is that one of the things is that a deed has certain basic requirements. They're really not that fancy, but they are required. As you know, we've talked about the statute of frauds before. Any real estate transaction requires some kind of a document. If you're going to convey real estate to somebody, you cannot do it on the basis of a handshake. Now, in the old days, I'm talking way back, 1300, 14, 1500, they would have a ceremony where they were going to sell the farm to another guy. And they would go out, and nobody could read and write anyway, except maybe the somebody in the church, like a monk or somebody like that. So what they do is they go out and they grab a big old hunk of dirt, and the one guy'd pick up the hunk of dirt, the seller, and then he would give it to the buyer, and that ceremony would be witnessed by all these people. Okay, and so that was the ceremony of seizin, which is like it's S-E-I-S-I-N, okay? So this whole thing about seizin is the ownership, and so it's a warranty that, hey, now this is your land, I'm giving you this land in exchange for the consideration of the money that you gave me, okay? So the witnessing of this transaction carried forward throughout time, but it was a written document then, because then more and more people could read and write, and they said, we need to get this down in writing so that we don't have to have a town meeting to figure out who owns what land, because somebody elderly could say, well, yeah, I was at that ceremony of seizin where Jones gave this ground to Smith. What if all those people die off? What if there's a disease comes through, Black Death or something, kills off all the elderly people? So basically you would lose track of that. So what ended up happening was that this whole thing started to be put in writing, but the witness requirements carried forward, okay? And so many states, I know when I lived in Ohio, there was a requirement that there was a notary that signed the paper and at least one other witness, sometimes two. But in other words, you had to have witnesses to the transaction. If the owner signs his name as a seller on this deed, then someone had to say, yes, I saw him do it. And in the case of Ohio, there had to be a notary and another witness, which was very difficult. You go to a notary's office, but have you ever been in one? Sometimes it's a guy that's in a little gas station. It's just him. There's no witnesses floating around. One of the biggest no-nos in terms of witnessing, the grantee, the grantee's family, which is the guy that's the buyer that's receiving the property, cannot sign the deed. He cannot sign as a witness. Very important. Never, never, never have the grantee or the buyer sign the deed. So that's important. Well, some states in the United States still require those witnesses, and it's shrinking. It's a smaller and smaller number. For example, Connecticut requires 2 witnesses plus a notary. Florida requires 2 witnesses plus a notary. Georgia, 2 witnesses plus a notary. Louisiana, 2 witnesses, but one of them cannot be a notary, so it would be a notary plus 2 witnesses, okay? South Carolina, 2 witnesses, but one may be the notary, okay? Now, Ohio is interesting. When I bought my home in Ohio, there was a witness requirement, but one of the witnesses could also be the notary. So you usually had like a secretary in the lawyer's office was a notary, and the lawyer was a witness, or vice versa. Lawyers in Ohio were automatically notaries, and so that was part of their officer of the court status. And so they would usually have a secretary, and so the 2 of them would sign a deed if you did it in a lawyer's office. But in 2001, Ohio did away with the requirement that there be any witnesses other than a notary. And basically Rhode Island has changed it to no witnesses. Texas says no witnesses. Vermont says no witnesses. And in Indiana, there is no requirement for witnesses except for a notary. So that's very important to keep in mind. It's also, we talked about this whole covenant of season. And so basically that is one of the covenants, that's one of the warranties. It has to do with the ownership. The right to convey is another covenant. In other words, the warranty of the seller, I am able to sell this. And then a covenant against encumbrance. I warrant that I have no outstanding loans or mortgages or judgments against me that hampers my ability to sell my real estate. Okay, so that's all of the above. Basically what you're looking at is that all those warranties attach when the seller signs that deed. Okay, another thing to keep in mind is that every part of a deed has a name. Okay, so a deed, for example, has a caption, and it's a real flowery, formal wording, you know, and then on down it has a description of the property. It has to be exactly correct. You cannot have mistakes in the description. In fact, I've seen some of these title companies now, they're so sloppy, they goof that up, and you bring that to their attention, they just take a pen and they just mark it out and write up above. And I'm like, you can't do that. You got to do this whole thing over. Oh no, we don't need to do that. And then there's a thing called a habdendium clause. Habdendium clause is what it's called, and that has to do with the actual transaction. Terms of the transaction, I'm giving you this in exchange for that. And you're going to own this property. And then at the bottom it's called a testimonium, and that's where the seller signs, the notary signs, and that's saying, you know, yes, it's all legal, this is true, this is really the guy. So those parts are required. There's 4 parts in every deed. Now, quitclaim deed, a lot of people get confused, and I had a secretary one time that was just so want to use a quitclaim form. She didn't understand the difference between a warranty deed. She said, well, what's the difference? You know, well, there's a huge difference, okay? A quitclaim deed says that I am quitting to you any interest that I may have in this property, as opposed to I guarantee in a warranty deed that I warrant that I own this property, that it's free from judgments, that it's free from any kind of loans, that it's free from any kind of mysterious thing that pops up from 100 years ago that would say that I don't really own this. And so it's a free exchange. You can warrant that, yes, it's true, I own the property. Most of the time, quitclaim deeds are used for like a limited purpose executor's deed. So the man dies or the lady dies, when the kid gets appointed executor by the judge, and he goes through and gets it all fixed up, cleaned out, and sells it to someone else, and he signs an executor's deed. Well, that has no warranties on it. Okay, now in all likelihood, it'll be free and clear because of the estate itself. Make sure that all the bills get paid and everything gets resolved. But in this particular case, executor's deed does not have warranties. Other thing is administrator's deed, and that is actually where there's no will, but it's the same type thing. It can also be a form of a deed that's involved in a receivership or some other kind of judicial proceeding. Trustee's deed, if someone forms a trust and then the trustee decides to sell a real estate, he is not giving you any warranties when he sells you that. It's a quitclaim type deed. And then of course foreclosure deeds that the sheriff gives you, like if you buy a house from the bank when it's foreclosed on, then there are no warranties with that. There's no real proof of ownership. Okay, so basically one of the things to understand that if the grantee possesses a deed, then it is a known fact that the deed, if it's in proper form and it's all done, then it means that the grantee was delivered the deed. The grantee has a deed, so he has a presumption of delivery. On the other hand, if the deed is in the hands of the grantor, then there's a presumption of non-delivery. It's really basically pretty simple. So unless and until that deed actually gets recorded at the courthouse, it is really not official. It is kind of a thing where it's declaring to the world at large that, Jones is no longer the owner, Smith is now the owner. And in the old days that I was telling you about, like 1300, the way that was done, because there was no writers and nobody that knew how to read, the man took a clump of dirt and gave it to Smith. Okay, so Jones gave a clump of dirt, and there's all the townspeople are watching. So that is their world. That's the world at large. But the way it's done now, it's all electronic. They scan that deed into the records, and so everybody knows, whether it's banks, whether it's creditors, whoever it is, can look up there and find out who the real owner is of this property. So if the grantee, for example, gets the deed and claims that he didn't get the deed, it's really on him if he doesn't record that deed. That's his problem. Okay, now future covenants. The covenant of season is not a future covenant because it is actually it is a present covenant. So in other words, it's saying, I'm giving you my ownership now. Now whatever happens in the future, that is a different kind of covenant, and we'll talk about that a little further down the line. All covenants run with the land, and these include covenant of quiet enjoyment, the covenant of further assurances. If there's anything that's not right with it or whatever, then it's really the duty of the seller to make it right according to the agreement of the parties. And then, of course, the covenant of warranty. Yes, I'm the owner. Yes, it's free from any kind of claims. So this is now your property. Okay, these are all covenants that run with the land and are enforceable. Now, none of the covenants exist in quitclaim deeds. That's what I tried to cover earlier. In other words, that covenant of season, which is to say the ownership, the covenant against encumbrances, which is like mortgages, judgments, any kind of loans that include a mention of the real estate, that is not in a quitclaim deed. There's no warranties, there's no agreements, there's no promises, just saying if I own anything in this real estate, it is now yours. Also the covenant of quiet enjoyment. So in the future, you're sitting on your porch, you're watching the squirrels picking up nuts and taking up in the trees in the fall, and up walks the man from the bank and says, "Who are you?" And you say, "Well, I'm the owner." And he's like, "No, you're not. The bank is the owner." So basically that's what can happen with a quitclaim deed. So you want to be sure that you always get a warranty deed and don't get in that trap of saying, well, the easiest and quickest way is a quitclaim deed. Yeah, it's easy and it's quick, but it's not good, So basically, remember, like I said earlier, always, grantee cannot sign the deed, the grantee should not witness the deed, the seller signs the deed, and the seller's notary signs the deed in Indiana. Okay, another thing is that this present covenant the covenant of quiet enjoyment is not a present covenant. It is a future covenant. So what that means is for the rest of your days, you can sit on your porch and nobody will bother you. Once again, let me reinforce and say to you, a deed must always be in writing, always be in writing. The other thing is that anytime there is a deed, it should mention consideration. Now in Indiana, there's a new rule, and it's a federal rule actually, but it used to be for many years, for generations, the rule in Indiana was, well, I'm paying $1 and other valuable consideration. Well, what is that other valuable? Well, it's not mentioned in the deed because people don't want other people knowing their business. Well, the IRS wants to know your business, and what they're finding is a lot of drug dealers and gamblers and people like that were using real estate as a method of conveyance of a lot of ill-gotten gain. So they were claiming on the form that they only paid $1 for a property and then passing it off to somebody. Maybe they paid $75,000 as the other consideration, but it doesn't show up anywhere. So the IRS says, well, there's another form you got to fill out that it'll just be in the recorder's office, the auditor's office, place like that. Will not be for the public to see, but in that form you got to tell what you actually paid. And I know of a case where a lawyer got himself in bad trouble because he put $1 on that form as well as on the deed, and it came down on him like a house of bricks, and so that was not good. Well, remember that there has to be valid consideration, and under current law, federal law, it has to be disclosed in a disclosure form in addition to the deed. So in the deed, you can still put $1 and other valuable consideration, but in the disclosure form that goes with the deed, parties have to both sign, and it has to say paid $75,000. So that's the modern times that we live in. Remember, I said to you earlier that the grantor, if he still possesses a signed deed after the date that it was supposed to be delivered to the buyer or grantee, then there is a presumption of non-delivery, meaning if it's in his hands, it sure didn't get in the grantee's hands, so something's wrong. If there's no express covenant for title, then the full risk of title failure falls on the buyer. So it's kind of a buyer beware thing, that the buyer needs to step forward and always protect himself and make sure every I is dotted, T is crossed. You know, everything's got to be right. It's got to be the actual correct description to the property. That is really a problem early on in some descriptions that I read. I would even take like a yellow pad of paper, like we were showing you about how to do descriptions of property, like surveyors, how surveyors do it. And I would, if it didn't come out to a square or a rectangle or some kind of a shape where it was a closed shape all the way from one end around back to the beginning point, then something's wrong. You cannot have an open-ended piece of property, and I'm going to draw this for you, what I mean. So they give you a description, and it's like from this point to this point, from this point to this point, from this point to this point, and back to the place of beginning. Okay? If that sentence is not in there, and back, or phrase, and back to the place of beginning, then you don't have, it's not a tract of land, it's not a full tract. So what you can get is, you'll see this once in a while, but a lot of people just ignore it. They don't pay attention. And you can get all different oddball shapes, but you get something like that. Somebody writes it up like that. Well, that's not, what is that? Is that all of this, or just what is it? You know, so you don't have a closed loop, you don't have a total piece of property, you don't have a correct legal description. There was one, and this happened a lot in Kentucky, but there were actually companies that were selling triangles, and it was on a circle, it was on a cul-de-sac, so there's a road that goes around like this, and you would put your house up in the front like this, and then as it went back, your property would narrow until at the end here, but it was still, there was a lot of property here. You can have a playground for your kids and playhouse or something, because usually in that back part, it was a little smaller. But the problem with this became when they started screwing up the surveys, and so this one went like this, but the other side of it went like this. So this is what we call a shingle survey. A shingle survey. And what do we mean by shingles? You ever see shingles being laid on a house? Shingles are laid like this, okay? So there's one, and then there's one like this, okay? And then on top of it, there's another two of them like this, okay? So they overlap, so it's overlapping survey. You don't want a shingle survey on your real estate, whatever you do. These overlapping surveys will get surveyors in trouble quicker than just about anything. So that's where some of these questions about the future quiet enjoyment of your property can be at issue. If your description in your deed is not correct, then that can cause a lot of trouble. Okay? Now always remember again, like I told you before, deeds must have consideration. So it's got to be mentioned in that deed somewhere, at least $1 and other good and valuable consideration. Okay? And usually it's $1 and 74,999 other dollars, you know. But you don't tell that because you don't want your gossipy neighbor to know what you paid for your real estate. Well, basically, remember again we said the grantee should never sign the deed as a witness or in any way. That is not right. Grantees don't sign deeds, only sellers and notaries. Basically, a general warranty deed is required for any sale to be absolute, final, for you to be protected. A bank won't probably loan on a property unless there's a general warranty deed, quite frankly. Basically, the covenant of quiet enjoyment is that in the future you can live in peace on your property without anybody coming forward and saying, hey, this is my property. No, it's not. You know, it's my property. That should all be resolved by the deed. The implied warranty of title is only true in the warranty deed, and I keep saying that to you. There is no implied warranty of any kind in a quitclaim deed, so keep that in mind. Okay, also, when you have a limited warranty deed, that's not good enough. You need a general warranty deed, because a limited warranty deed, all that gives you is says, during my ownership, there have been no liens placed on this real estate. Okay, so that is the ownership of the seller. Well, what about the prior owners behind him? Did they have judgments against them? And whatever happened to them? Were they extinguished in some way? You know, so that's always a problem. Basically, remember that we told you that there are only certain states that require witnesses in addition to a notary, and that is a dwindling number. And so basically, you know, as we go along, it'll probably be one of those things you never even have to worry about. Here in Indiana, as I said before, the important thing to remember is that the warranty and all of that attaches on the signature of the grantor or the seller and the notary. So it's the seller and the notary, only ones that need to sign that warranty deed. Okay? So basically, property, we've been talking about deeds today. If you have any questions or problems, be sure to give me an email. You can email me in my private email or in my campus email, either one. Be glad to try to help you if I can. Appreciate all your hard work, and let me know if I can help you in any way. Pleasure working with you, basically let's move forward and finish up. We're moving into the Chapter 8 area, so we need to be thinking about that midterm test and any other kind of writing assignments and so forth, and try to keep up with the discussion boards and just follow along and finish out strong. Thanks a lot.